Been following in the news a extraordinary horror story, and it's the story of Kermit Gosnell's really unspeakable crimes that were committed over a long period of time, maybe as much as 2 decades, at the Women's Medical Society in Philadelphia, Pennsylvania. We suspect that there were literally hundreds of late-term and very late-term abortions that were conducted there. And we now know from his conviction in a criminal trial that there were babies born alive, probably many, who were then murdered when scissors were used to sever their spinal cords after they were born alive in a failed abortion attempt. Further, we know that Kermit Gosnell and some of his colleagues kept aborted fetuses in bags and bottles, discarded them, left them on shelves. It's just unbelievable what was happening at this place for years and years. In fact, the crimes were discovered by accident. Police raided offices to seize evidence of illegal sales of prescription drugs, and it was only during that raid for illegal prescription drug sales that they discovered the evidence of these atrocities. It's my view and the view of many of my colleagues that we need to do a lot more to make sure that the laws, which were blatantly being violated by Kermit Gosnell, are better enforced. And we need to do that through proper due diligence and discovery of where they're being violated. Just about 2 weeks ago, Kermit Gosnell was convicted. He was convicted of 3 counts of first-degree murder for killing 3 infants. He was convicted of 1 count of third-degree murder in the overdose death of a woman. There are 21 counts of abortion of an unborn child 24 weeks or more, and he was convicted of 208 counts of violation of informed consent. Madam President, we have a resolution. It's Senate Resolution 133, and it points to these atrocities that were committed, and it simply calls on Congress and the states to investigate and correct the abusive, the unsanitary, and the blatantly illegal abortion practices that certainly were conducted here at the Women's Medical Society in Philadelphia, and similar such practices that may be occurring in other places. So I ask unanimous consent the Health Committee be discharged from further consideration of S.Res. 133, that the Senate proceed to its consideration, that the resolution be agreed to, the preamble be agreed to, the motion to reconsider be made and laid on the table, and no intervening action or debate.
Is there objection?
Madam Chairman.
The Senator from Connecticut.
Thank you, Madam President. Reserving the right to object, and I will object, but I want to first discuss the resolution that now for the 3rd time essentially has been brought to this body, and I'm here to speak and object for a 3rd time, but not from out of disagreement with the basic goal that has been well articulated by my friend from Pennsylvania. And I think I'm quoting him directly from his remarks just now in saying that goal is to do a lot more to assure that the laws violated by Kermit Gosnell are vigorously enforced. I am here to say yes. Let us condemn the kinds of practices that resulted in that conviction of Kermit Gosnell and his sentence, in effect, to life in prison. Let us do more to assure that laws are vigorously enforced that protect innocent patients in any setting, whether it's a doctor's office or a hospital or a nursing home, whether it's by a nurse or a doctor or another kind of caregiver, or by a vicious, conscienceless practitioner like Kermit Gosnell. Let us stop this kind of despicable medical conduct, even if it may be only a tiny fraction of all the caregiving that occurs in the United States, by an even tinier fraction of a great and noble profession by extraordinarily experienced and expert members of our medical profession. We need to talk about all of the kinds of malpractice and criminal misconduct that can cause death or injury or the threat of death or injury. And we ought to be equally outraged by the doctors and the nurses in states like, for example, hospitals and nursing homes in both New Jersey and Pennsylvania in 2006, sentenced to multiple life sentences for killing at least 29 patients by intentionally overdosing them with medication. There was simply no justification for those actions, and they are equally heinous and unforgivable as the crimes that resulted in the conviction of Kermit Gosnell. We need to talk about the nurse who was charged with killing 10 patients in a hospital in Texas by injecting them with a medication to stop their breathing. She pleaded no contest and now is serving life in prison. I want this body to adopt a resolution that addresses those kinds of lapses in basic decency and ethics and morality as well as law. We ought to be talking about the doctor who worked in hospitals in 7 states, New Hampshire, Kansas, Maryland, Pennsylvania, Michigan, New York, and Georgia, and exposed almost 8,000 patients to hepatitis C. He knowingly injected patients with his own infected blood and exposed them to life-threatening disease. And the resolution that I am going to ask this body to adopt speaks to those violations of trust and decency and law. In this place, I've talked about other similar violations. The Oklahoma dentist who exposed as many as 7,000 patients to HIV and hepatitis B and C through unsanitary practices. In Nevada, the practitioners at an endoscopy center that exposed 40,000 patients to hepatitis C through their unsanitary practices went on for years. My resolution speaks to those basic violations of trust and morality. Kermit Gosnell's case has run its course. Our criminal justice system has done its work. I have a resolution, and I ask unanimous consent that it be adopted. I ask unanimous consent that the Help Committee be discharged from further consideration of S Resolution 134 and the Senate proceed to its consideration, and that the resolution be agreed to, the Blumenthal amendment to the preamble, which is at the desk, be agreed to, the preamble as amended be agreed to, and the motion to reconsider be laid upon the table with no intervening action or debate. I object to the resolution offered by my colleague from Pennsylvania and ask him and my colleagues to join me in support of this alternative resolution.
Objection is heard. Is there objection to the request from the senator from Connecticut?
Madam President.
Senator from Pennsylvania.
Reserving the right to object. I think the senator from Connecticut makes a number of important observations, raises a number of very important issues, and I think there's an opportunity for the two of us to work together to address some of these things. However, my reading of the actual resolution for which he is requesting unanimous consent, in my view, equates outcomes, including deaths, but outcomes resulting from malpractice and unsanitary conditions and other completely indefensible practices, equates those with the serial, premeditated, intentional murder of babies. And I don't think those things ought to be equated because I think they are of a very different nature. Furthermore, the resolution of the senator from Connecticut, as my understanding, does not call for the investigations that I think are necessary. to determine how widespread these practices are, under what circumstances they're occurring, and what more can be done to prevent them. And so for those reasons, Madam President, I object.
Objection is heard.
Madam President,
The senator from Tennessee.
does the senator from Connecticut have anything further? The senator from Pennsylvania, I don't want to interrupt their discussion.
I am done, Madam President. I appreciate the senator from Tennessee's inquiry. Thank you.
The senator from Tennessee.
Thanks, Madam President. Madam President, being a majority leader is not an easy job, whether you're a Republican or a Democrat, and some good things have been happening in the Senate recently, and I think we should credit both the majority leader and the Republican leader with helping to make that happen. Over the last few weeks, we've seen the Water Resources Bill come to the floor, and the majority leader allowed Senator Boxer, Senator Vitter to manage the amendment process, to handle the necessary arguments that always occur about what they will be, and we came to a conclusion and passed a bill. A bill that went through committee, went through the floor. It's a very important bill, really, because it deals with locks, dams, ports in the United States. We want to make sure that as the Panama Canal is widened and deepened, that the ports in the United States are deep enough to receive the bigger ships, and that the locks and the dams are in good enough shape so that commerce can move through the country and jobs can be created. So that's an important piece of legislation. And now we're on the Farm Bill, and we see the senator from Mississippi and the senator from Michigan managing a bill. There's plenty of opportunity for amendments, so far as I've been able to tell, and that has been very helpful. At the same time, we have coming out of the Judiciary Committee, after several days of intense work, a bill on immigration. Probably the four most important words that could be said about the immigration debate is that we are all Americans. And Americans know that we must have a legal immigration system if we want to be able to say we're all Americans. And we want one, and we don't have an enforceable legal system today. All of us know that. None of us like the status quo, I don't think. And all of us know that the President and the Congress are the only ones who can fix it. This is not something we can dump on the mayors or the state legislatures. And so I think many of us haven't formed a final opinion about this legislation that's coming forward, but I, for one, respect the fact that it's moved, that it has 4 principal Republican sponsors and 4 principal Democratic sponsors, and it's moved through the committee, and voices have been heard, and it's coming to the floor. And again, the majority leader has indicated, and the Republican leader has agreed, that when it comes to the floor, there will be a full and open debate so the American people can see it and watch us come to a result. All those are good things. And in addition, so that we might do that, there are a number of nominations about which we're likely to disagree that will be after that, so as not to interfere with the immigration debate. Which brings me to my final point. I would hope that the fact that with occasional interruptions for debate over whether we're going to go to a budget or not, which I hope gets resolved, we're on a pretty good path right now. And I hope the majority and the minority leaders can see that. We're moving this afternoon to a vote on a federal appellate judge for the D.C. Circuit. A major objective of the Democratic side has been to get another judge on that circuit. And the President has nominated a person, Mr. Srinivasan, who by every account is an exceptional attorney. He came out of the committee with an 18-0 vote, has widespread respect and support, and the only glitch in the process was that the majority leader felt it necessary to file a cloture motion this week, even though the Republican leader had agreed that we would have an up or down vote on the Monday we get back. And every indication is that almost everyone would vote for that judge. Now that's been resolved, and so we're going to vote this afternoon at 2 o'clock, and I know better than to predict how the Senate will vote. I'm going to vote for Mr. Srinivasan. I suspect he'll be easily confirmed. But in all of this, the majority leader has felt it necessary to suggest that somehow there's a problem with the president's nominations being considered by the United States Senate. And I think it's important that someone other than the Republican leader, because it's his job really to defend our side, to lay out what the facts are. And I hope I can do that with some credibility, because I've worked with my Democratic colleagues at the beginning of the last Congress, at the beginning of this Congress, to make it easier for this president and future presidents to have their nominations considered. We've changed the rules to make it easier. Just a few months ago, in a long discussion that involved senators from both sides and a debate on the floor, we made a number of changes to make it easier for a president to have his nominations considered. One of the examples adopted 2 years ago was the expedited nominations, where a nomination simply comes to the desk. And if a single senator doesn't want it sent to committee, it just sits there until all the paper is in, and then the majority leader may just move it on. Within the next few days, there will be a number of those that come out of the Health, Education, Labor, and Pensions Committee. That speeds things up. We removed from the list of nominations about 160 nominations. They're not subject anymore to Senate advice and consent. The president may just go ahead and appoint those persons. We've gotten rid of the secret hold, which was used for a long time to hold up nominees or even to block them because no one knew who was doing that. Earlier this year, we changed the rules so that when a district judge comes up, that there can't be a long debate after the district judge comes to the floor. And as a result, things are moving along very well. So I would like to say that there is not a problem with the president's nominations being considered in a timely fashion by the United States Senate. There is no problem. There is the responsibility for advice and consent. I mean, most of our founders did not want a king. They created a Congress and a Bill of Rights, and they said, here's an advise and consent. So we have about 1,000 people that the president will nominate that we're supposed to consider. We should do that well. That's our job to do. And it's our check on a runaway executive. I used to, when I first came here, Senator Byrd made wonderful speeches about that. Senator Kennedy from the back row with that big booming voice. I remember his speeches about President George W. Bush's recess appointments and how offended he was by those because they offended the Constitution. And Senator Byrd, as I mentioned, was very eloquent, going all the way back to President Reagan's days. So we've always jealously defended the people's right to have an elected group of representatives to check the executive. And we need to use that in a responsible way. So it's important to have an accurate report on just how well President Obama is being treated by the United States Senate in terms of his nominations. Now, I've just noted that we've changed the rules to make it easier. I did not even say that we have even made it easier for the nominees. We set up a working process to make it, I like to call it the innocent until nominated syndrome. You pick some well-respecting person from the Midwest and send him or her nomination to the Senate, and all of a sudden it's as if they were a criminal of some kind. And that's because there were so many conflicting forms to fill out that it was easy to make a mistake and look like you were misleading the Senate. Well, we've tried to simplify that. And this president is the first beneficiary of that. So this president is the first beneficiary of consecutive Congresses who have changed the rules to reduce the number of presidential nominees subjected to advise and consent, expedited a number of others, and made it easier and quicker for the president to have his nominations considered. This president is the first to benefit from that. And so what are the results? I mean, the majority leader suggested that there was delay and obstruction. I mean, that word just comes out, automatically sometimes when people wake up in the morning on that side of the aisle. But let's look at the facts. I asked the Congressional Research Service to take a look at the Washington Post article that wrote earlier this year. Now, these are not Republican people I'm asking. This is the Congressional Research Service. How is President Obama being treated in terms of his Senate nominees? According to the Congressional Research Service, as of May 16, 2013, that's last week, President Obama's cabinet nominees were still, on average, moving from announcement to confirmation faster than those of President George W. Bush or President Clinton. President Obama's nominees were moving from announcement to confirmation at that time last week 50 days. George W. Bush averaged 52 days. President Clinton averaged 55 days. So let me say that again. President Obama's cabinet nominees are moving ahead in the Senate more rapidly than those of his two predecessors. One of them President George W. Bush, one of them President Clinton. So there's no delay there. That's unusual. It's not unprecedented, Madam President, for some second-term nominations to take much longer to move from announcement to confirmation than the average. President Clinton's nominee for Secretary of Labor, Alexis Herman, took 135 days. President George W. Bush's nominee for Attorney General Alberto Gonzales took 85 days. I remember the case of one especially distinguished nominee for the Secretary of Education by President George H.W. Bush, a former governor of Tennessee. His name was Alexander. His nomination took 88 days from announcement to confirmation. And President Reagan's nominee for Attorney General, Ed Meese, took nearly a year. Now, that's an unusual case, but it's not so unusual for second-term nominees to take a little while for the Senate to perform advice and consent. And as the Congressional Research Service and the Washington Post have reported in their own analysis, President Obama's cabinet nominees are being better treated than either President Bush's or President Clinton's in terms of the time it takes to confirm them from announcement to confirmation. Now, one last thing. What about judges? Sometimes I've heard senators on that side and senators on this side get up and give conflicting information about whether judges are being considered rapidly. Here's what the Congressional Research Service says about the judicial nomination process. If Mr. Srinivasan is confirmed today, as I expect he will be, President Obama will have had 20 judges confirmed at this point in his second term, including 6 circuit judges and 14 district court judges. At this point in his second term, President George W. Bush had 4. 20 for President Obama, 4 for President George W. Bush. No unusual delay there. Apparently, President Obama's nominations are being considered more rapidly than those of President Bush. And to be specific, let's go to the district court nominations. Now, we know, with all the talk of a filibuster, that in the history of the Senate, there's never been a nominee for district federal court judge ever be denied his seat by a filibuster after that nomination came to the floor. So that needs to be said, too. But right now, there are 5 pending district judge nominations that have been reported from committee that haven't been confirmed. There have been 33 nominations this year. 14 already are confirmed. 5 are reported from committee, as I said, in await floor action. They were reported in May, April, and 3 of them in March. So there's no big backlog. There are 5. They were reported in the last few weeks, so no excessive delay there. And finally, on circuit court nominations, I mentioned that we're likely to confirm one of the 3 that are today pending, Mr. Srinivasan. 12 nominations of federal circuit court judges have been received this year. 6 will have been confirmed after this afternoon. That leaves two circuit court judges who have been nominated by the President and await floor action. They were reported by the committee in April and February. So I can't find any evidence of any delay on cabinet members. In fact, President Obama is being treated better than his predecessors. I don't see any evidence of any delay on judicial nominations. President Obama's got 20 confirmed in the second term. President Bush had 4. And there are only 5 pending district court nominations, all reported within the last few weeks, and there are only 3 circuit nominations, one of which is likely to be confirmed this afternoon. And on that one, the majority leader indicated Mr. Srinivasan, who has such wide support on both sides of the aisle, had been waiting forever. Well, he has waited a little while. President Obama nominated him on June 11, 2012. But why did he wait? Madam President, he had no hearing. Who's in charge of setting hearings? The Democratic majority is setting hearings. The Republicans can't call a hearing in the Judiciary Committee. So their nominee, Mr. Srinivasan, sat there all of last year after June 11th without a hearing. There may have been delay, but that was self-inflicted delay. And what about this year? Mr. Srinivasan, here's the timeline. He was nominated again on January 4th by the President. His hearing was April the 10th. Now, I don't know why they had to go from January to April to have a hearing, but again, that's solely within the control of the Democratic majority. He returned his questions that we all have to. We're nominated for an executive position on May the 6th. That's this month. The committee considered his nomination May 16th. That's last week. They approved it 18-0. That's all Democrats, all Republicans voting yes. He came to the calendar of the Senate on May 20th. That's on Monday.
Will the Senator yield? Under the previous order, the Senate will proceed to executive session to consider the following nomination, which the clerk will report.
Nomination. Srikanth Srinivasan of Virginia to be United States Circuit Judge for the District of Columbia Circuit.
Under the previous order, there will be 60 minutes of debate, equally divided in the usual form.
President, I'll conclude so that those who are expecting to do that, but these are timely remarks. So Mr. Srinivasan, nominated in June 11th of 2012, no hearing by the Democratic majority in the Executive Committee. I wonder why. Nominated January 4th by President Obama this year, again, no hearing until April 10th. If there's any delay there, it has no fault anywhere on the Republican side. May 6th, questions returned. No nominee is considered by the committee until his questions come back. Marked up May 16 last week, 18-0, unanimous, came to the floor on Monday, and the Republican leader moved yesterday to ask unanimous consent that we consider an up or down vote for Mr. Srinivasan when we return after a week, which means he would have been fully considered then, to which the majority leader put down a cloture motion. Now, he's removed the cloture motion, but there was no need for the cloture motion. The only suggestion may be that he wanted to look like that there's some delay over here. There's no delay over here. The president's nominees are being better treated than the last 2 presidents. There's no backlog of judicial nominees. Mr. Srinivasan has broad support. We are ready to vote for him up or down, and I think it's time we got away from this idea of manufacturing a crisis about nominations when, in fact, we've made it easier for any president to offer his nominations, and the majority leader and the Republican leader agreed at the beginning of this year when we did that that was the end of the rule changes for the Congress in this Congress. I thank the President. I yield the floor.
President.
The Senator from North Carolina.
Madam President, I ask unanimous consent to speak for 5 minutes on the Feinstein Amendment.
Without objection.
I thank the President, and let me first say about Senator Alexander's comments. What you see is why this is a former university president, a governor, a secretary of education, a candidate for president, and now some would call him a senator. I think you call him a statesman, because he tries to lay it out in a way that we can all understand it, with facts and not hyperbole. And this is an opportunity for us on both sides to step back from the brink and to actually do the people's business, to get something done, to solve big problems. Madam President, I came to the floor to talk on the Feinstein Amendment, knowing that it's not up for an hour, and I will be very brief to my colleague in Virginia because I know he wants to talk about judges. Primarily because there is some misinformation that's been stated. Now, let me recap the tobacco industry in a very brief summary. Tobacco, like many agricultural products, for years received a price support system that the federal government, the Congress of the United States, put in place. And a number of years ago, members of Congress said, for obvious reasons, the federal government probably shouldn't have a price support on something that we consider not to be best for people's health. And at that time, farmers reluctantly listened to members of Congress that said the international market should be open to you and we should do our best to make it unlimited. And we did. And at that time, we eliminate the price support system. Senator Feinstein came to the floor, and I don't think she did this intentionally. She said that it costs the American taxpayer $10 billion. In fact, there wasn't one dime of American taxpayer money that went to the tobacco buyout. 100% of the cost of that, elimination of that program, was absorbed by the tobacco companies. So yes, if the purchase of a pack of cigarettes and the profit that goes to a tobacco company and the $1.01 in federal taxes that they pay per pack of cigarettes is the American taxpayer paying the price of the buyout, then she's right. I'm not sure that you can make that connection. But I want to state for my colleagues, the federal treasury did not pay $10 billion to buy out tobacco farmers. It was the companies, the ones that understand that they've got to have a viable, abundant source of product. 60% of what we grow in the United States is shipped for export. It doesn't go to the domestic market. Now, let me say to my colleagues, if the intention of this is to be punitive to this product, for gosh sakes, come to the floor, change your amendment, let's vote up or down as to whether tobacco is going to be legal or not. If the purpose here is to suggest that we're going to save taxpayer money, well, let me suggest that if you put every tobacco farmer out of business, and this is the commodity that achieves actually our best balance of trade in agricultural products, you'd make a real long-term mistake. The only thing this commodity, this agricultural commodity asks is let us participate in the federal crop insurance program. Without that protection, it is impossible for my neighbor, your neighbor, the backbone of a community, a farmer, to go to a bank and say, can you lend me enough money to plant my crop this year, and if Mother Nature's good and I work hard, I'm going to be able to sell this product, I'm going to be able to pay you back, and I'm going to be able to make a profit to feed my family. Without that assurance of a safety net, they would never get the bank to loan the money. This is about availability of capital. This one clause. Why in the world we would pick out one commodity out of the entire ag industry and say everybody else can participate in the crop insurance program, but you can't, is insane. So, Madam President, let me say to my colleague from California, Senator Feinstein, I don't think this was intentional. I think she either got bad staff information or she just made a gaffe. To my colleagues, let me encourage you, vote against this amendment. Don't do this to a piece of the ag community that is profitable, that works hard, but more importantly contributes a lot to the backbone of this country. I thank the President. I yield the floor.
Madam President.
The senator from Virginia.
Madam President, I rise to support the nomination of Sri Srinivasan to be a judge on the U.S. Court of Appeals for the D.C. Circuit. This matter will be before us for a vote later today, and I just wanted to speak a bit about Sri's significant qualifications. I'm going to discount the fact that he was born in Kansas and raised in Kansas like I was. I won't take that into account, and I'll discount the fact that he lives in Virginia now like I do and focus on other qualifications because he's got them by the boatload. Sri has a wonderful background that equips him for this most important judicial position, and this has been a position vacant since June of 2008. He was an undergrad and then law degree and then business degree, MBA at Stanford after he grew up in Lawrence, Kansas. Like many law graduates, his next step was to work as a clerkship with appellate judges. He worked first for a wonderful Virginia jurist, J. Harvey Wilkinson, who was the Chief Judge of the Fourth Circuit Court of Appeals, headquartered in Richmond. Judge Wilkinson is well known as a superb legal scholar and judge. After he completed that clerkship, he had the honor of being selected to work as a clerk for Justice Sandra Day O'Connor, also a tremendous honor for a young lawyer. And I talked at length with Mr. Srinivasan and heard about the fact that he learned a great deal from both of these judges about judicial temperament and the importance of so many aspects to be a good judge. Sri had the expertise developed in private practice at one of America's major firms, O'Melveny & Myers. O'Melveny & Myers has a very significant Supreme Court practice for years, headed by Bill Coleman, who was a longtime official, one of the lawyers who worked on the Brown versus Board of Education case in the 1950s. Sri eventually became the leader of the appellate practice at O'Melveny & Myers. In that capacity, doing good work. He's been a teacher at Harvard Law School, but probably most specific to the needs of the D.C. Circuit, Sri has had a long career working in the Solicitor General's office, the key legal office of the United States, charged with representing the United States on important matters before the Supreme Court and the federal appellate courts. He's worked in 2 stints in the Solicitor General's office, having worked both under the Solicitor General's office during President Bush 43's tenure, and then again returning to work as the Principal Deputy Solicitor General under President Obama. In that capacity, he has had extensive arguments, more than 20 arguments before the United States Supreme Court, and numerous appellate court arguments in the federal appellate courts, including the D.C. Circuit Court, for which he is nominated. Sri Srinivasan enjoys broad support. Numerous of the officials in the Solicitor General's office under both Republican and Democratic administrations have weighed in on behalf of his candidacy. The ABA, American Bar Association, that looks at candidates and scrutinizes their qualifications, has given him the most qualified award, their highest recommendation, and he comes with significant support in this body and others with whom he has practiced. The area that I probably spent most time with him on, Madam President, as I was interviewing him, was the whole notion of judicial temperament. These are important positions, and under the Constitution, we grant them to people for life. You can have all the intellectual qualification, but if you don't have the life experience to enable you to understand situations and pass judgment on matters important to people, and if you don't have the temperament to work in a collegial body, circuit courts, as you know, hear cases generally in panels of 3, and then occasionally hear cases en banc. The entire list of the circuit court judges for the D.C. Circuit would sit together. It's not enough to be a scholar. You have to be a good listener. You have to be a good colleague. Sri Srinivasan has a very his career is a track record to his dedication and his ambition, but his temperament is a real tribute to his humility, to his ability to listen, not only to litigants, but to other judges. And I think these credentials, both his formal credentials, his work experience, and his temperament would make him an excellent choice. And so for that reason, I'm proud to stand up as one of his home state senators, and I'm proud to acknowledge the Judiciary Committee's unanimous vote in his behalf, and I urge my colleagues today, as we move to the vote, to support his nomination. None of us will be disappointed in his work as a D.C. Circuit Judge. Thank you, Madam Clerk, and I yield the floor back.
Madam President.
The senator from Iowa.
I voted for this nominee out of committee, and I will vote for this nominee on the floor of the United States Senate. He's supremely qualified for this position. I come to the floor not to repeat what a lot of other people have said about this nominee, but the process that was connected with arranging the vote for this nominee. Basically, I want to speak about the needless shenanigans that have gone on before we get to this point where we vote at 2 o'clock. Today's nominee for the D.C. Circuit was voted out of committee 1 week ago, on May the 16th. A unanimous vote of 18-0. He was placed on the executive calendar 3 days ago, on Monday, May the 20th. One day later, on May 21st, the Republicans cleared this nominee to have an up or down vote when we return from the Memorial Day recess. But the majority leader was not content to take a yes for an answer. One day after this nominee was placed on the executive calendar, and after Republicans agreed to an up or down vote, the majority leader chose to file cloture. Why file cloture? Why would the majority leader do that on a nominee that the minority party, the Republicans, were ready and willing to vote on, backed up by the fact that every Republican on the committee voted for this nominee? There's only one plausible answer. That is part of the majority's attempt to create a mere appearance of obstruction where no obstruction ever existed. It's pure nonsense. It is a transparent attempt to manufacture a crisis that doesn't exist. The fact of the matter is that there is no obstruction, and particularly no obstruction on this nominee, and the other side knew it before they filed cloture. This morning in his opening remarks, the majority leader tried to argue that he has had to file cloture 58 times. But what the majority leader did this week illustrates precisely what the majority leader is trying to do. And that happens to fit into the majority's playbook, the playbook of the Democrat majority. File cloture for no apparent reason, none whatsoever, and then immediately turn around and claim, see, we had to file cloture. The fact of the matter is that we're confirming the President's nominee, all nominees, at our near record pace. After today, the Senate will have confirmed 193 lower court nominees. We've defeated only 2. That's 193 to 2, which happens to be in baseball a 990 batting average. And anybody would agree that that's an outstanding record. Who can complain about 99%? After today, this year alone, the first year of the President's second term, the Senate will have confirmed 22 judicial nominees. Now let's compare that when there was a Democrat Congress and the previous president in the first year of his second term, that of President Bush. So in this same period of time in 2005, the Senate had only confirmed 4 nominees. So that's a record of 22 the first year of this president's second term compared to only 4 for the first year of President Bush's second term. If we were treating the president in the same way the Senate Democrats treated President Bush in 2005, we wouldn't be confirming 22 nominees. We'd be confirming only 4. But we have these needless shenanigans going on. Anyway, based on that record, what can the President or the Senate Democrats possibly complain about? The bottom line is that they can't complain, or at least shouldn't complain, and that's based not upon rhetoric, but based on that record of 22 so far this year and 197 versus only 2 disapprovals. And of course, because the record's so good, the other side needs to manufacture a crisis. That's why the other side filed cloture on this nomination one day, just one day after it appeared on the executive calendar. Yesterday, when the majority leader was pressed on why he chose to file cloture one single day after his nomination appeared on the executive calendar, he pointed to the fact that the nominee was first nominated in the year 2012. But apparently what the majority leader has been unaware of, that the chairman of the committee, the Judiciary Committee, made no effort to schedule a hearing on this nominee until late last year. Apparently, the majority leader was unaware that by January of this year, we learned the nominee was potentially involved in the quid pro quo of Mr. Perez, the President's nominee for Labor Secretary, orchestrated between the Department of Justice and the city of St. Paul. And you may remember I spoke on this issue last week regarding the deal Mr. Perez struck, where he agreed the department would decline 2 false claims cases in exchange for the city of St. Paul withdrawing a case from the Supreme Court. I'm not going to go into those details again, but that is a very serious issue. The department, as it turns out, Mr. Perez in particular, bartered away a case worth about $200 million of taxpayers' dollars to come back into the federal treasury under the False Claims Act. Having that case withdrawn is a pretty serious matter. As it turns out, the nominee before us today happened to be the lawyer in the Solicitor General's office who handled the case for Mr. Perez, desperately wanted withdrawn from the Supreme Court. So as you would expect any member of the Senate, particularly the responsibility of the minority, our side needed to know what the nominee knew about the quid pro quo and what Mr. Perez told the committee about that deal. We needed the documents about this issue, and we needed to speak with the witnesses involved. But the department was desperate to keep those documents from Congress. They were desperate to keep the witnesses from being involved and interviewed. The bottom line is that the Department of Justice dragged its feet for months. Now, if the Department of Justice had turned over those documents and made witnesses available way back when we asked for them, the hearing for this nominee could have been one of the first that we had this year. But instead, the Department of Justice chose to try their best to keep Congress from getting to the bottom of that quid pro quo, and frankly, Mr. Perez's involvement in that matter. So if the majority wishes to complain about the nominee having his hearing in April rather than February, they should just pick up the phone and call those in charge at the Department of Justice. How come you didn't give Congress that information that they needed? So it wasn't the Senate Republicans who withheld the documents. It was this Department of Justice. It wasn't Senate Republicans who held up the nominee's hearing. It was the Department of Justice. The bottom line is that the Senate is processing the President's nominees exceptionally fairly. I don't repeat those statistics because I've gone through them, this speech and many speeches. This President is being treated much more fairly than Senate Democrats treated President Bush's in 2005. The fact of the matter is this: filing cloture on this nominee that probably will pass unanimously was nothing but a transparent attempt to create the appearance of obstruction. As I said, I intend to support this nominee, just as I did in committee, and I encourage my colleagues to support the nomination as well. But as we move forward on these nominees, I wish we could stop these needless shenanigans. I wish the other side would stop shedding those crocodile tears that the statistics of approval by this Senate of judicial nominees of 197 to 2 is no justification for any crocodile tears whatsoever. I yield the floor. And I suggest the absence of a quorum.
The clerk will call the roll.
Mr. Alexander. Madam President, I ask proceedings under the quorum call be vitiated.
Without objection.
Madam President, today this body will have the chance to vote on the nomination of the highly qualified Sri Srinivasan for the D.C. Circuit Court of Appeals. I'm a member of the Judiciary Committee and have had the honor, the privilege of chairing Mr. Srinivasan's confirmation hearing, and I can say without question he has the background, the skills, and perhaps most importantly, the temperament to serve as a circuit court judge. He's one of the singly most qualified judicial nominees I've seen in my years in this body, and he deserves better than the games that have been played with this confirmation. He already has bipartisan support. Now let's work together and give him a strong bipartisan vote. The Constitution of the United States gives the Senate the responsibility to advise and consent to the President's nominations for important posts, like the bench of the D.C. Circuit Court of Appeals. And it's certainly our responsibility to review and vet candidates, nominees who come over from the President. We should not simply serve as a rubber stamp, but neither should we be a firewall, unreasonably blocking qualified nominees from service at the highest levels of our government. Our nation's court should be above politics, and when the President submits a highly qualified candidate of good character and sound legal mind, as Mr. Srinivasan most certainly is, then absent exceptional circumstances, that candidate should be entitled to a vote. To this point in President Obama's administration, nearly 1,600 days in, the Senate has failed to live up to its responsibility and to confirm any nominee to the D.C. Circuit Court of Appeals. The D.C. Circuit Court of Appeals is often called the second most important in the nation because, like the Supreme Court, it handles cases that impact Americans all over the country from all walks of life. It regularly hears cases that range very broadly, from terrorism and detention to the scope of federal agency power. And yet it is today critically understaffed. The D.C. Circuit Court of Appeals has not seen a nominee confirmed since President George W. Bush's fourth nominee to that court was confirmed in 2006, 7 years ago. Republicans in this chamber filibustered President Obama's nominee, Caitlin Halligan, until she ultimately, after hundreds and hundreds of days of waiting across several Congresses, she ultimately gave up and withdrew. Her opponent said that the caseload of the D.C. Circuit was too low, that it did not deserve another judge. But such concerns about caseload didn't prevent the Republican-led Senate from confirming 2 nominees to the 10th seat on the D.C. Circuit and 1 to the 11th. Mr. Srinivasan stands nominated not for the 10th or the 11th seat on the D.C. Circuit, but for the 8th. Madam President, we need to confirm Mr. Srinivasan, and we need to act quickly on the President's next nominee for that court and the one after that. We have a chance, I believe, to start fresh with Mr. Srinivasan, who would serve equally well and ably on the D.C. Circuit Court of Appeals as might Ms. Halligan. Mr. Srinivasan has a razor-sharp legal mind. He served in the Solicitor General's office for both Republican and Democratic administrations and has earned the bipartisan support of his colleagues. 12 former Solicitors General and Principal Deputy Solicitors General wrote a letter supporting his nomination. 6 Democrats, 6 Republicans. The letter, which is signed by conservative legal luminaries such as Paul Clement and Ted Olson, notes Mr. Srinivasan is one of the best appellate lawyers in the country. They commented further in the letter that he has an unsurpassed work ethic and that he is, I quote, extremely well prepared to take on the intellectual rigors of serving as a judge in the D.C. Circuit. My point then, Madam President, a simple one, is this. Sri is a capable, in fact, a highly accomplished attorney with the character and the demeanor to serve admirably on this bench, which has sat without a nominee from the Obama administration for the entire time that our current president has served. Sri Srinivasan has earned bipartisan support. Now, today, let's give him a bipartisan vote. Thank you, and with that, I yield the floor.
The clerk will call the roll.
Mr. Alexander.
Hang on. President,
The senator from Delaware.
I ask that proceedings under the quorum call be vitiated.
Without objection.
Madam President, I ask that any time during quorum calls leading up to the vote be charged equally to both sides.
Without objection.
Thank you, Madam President. I yield the floor and suggest the absence of a quorum.
The clerk will call the roll.
Mr. Alexander.
Mr. President.
Senator from Kansas.
Mr. President, thank you. I would ask that the quorum call be eliminated.
Without objection.
Thank you, Mr. President. Mr. President, I'm certainly recognize that providing advice and consent to presidential nominees is one of our most important responsibilities as members of the United States Senate. And it's a responsibility that I expect and believe that all of us take very seriously. On a number of occasions, I've had the opportunity to meet Sri Srinivasan, who President Obama